Well, welcome if you're joining us today for our Constitution Day conversation. We're happy to have you, and we're just going to wait a few minutes while we get everyone on the call. I'm Mary Bilder, and we're broadcasting from Boston College, the Clough Center for the Study of Constitutional Democracy. So we'll just wait while everyone comes onto the call and we watch the numbers up, and we hope you're having a good day and that we're so happy to have you joining us today. Okay, well, why don't we begin? Thanks for joining us today. This is Mary Bilder. I'm a professor at Boston College Law School, and we're delighted to have you join us for our Constitution Day conversation with Professor Julie Suk and Professor Katie Young. This is a program co-sponsored by the Boston College Legal History Roundtable and the Clough Center for Constitutional Democracy, and I want to thank Julia Barrett, who's behind the scenes, who's helping us out today, and the center's director, Vlad Perjou. This is the first of 3 conversations we're going to be having over the fall, each on a Friday at noon, with people who think about the intersection of American legal history to modern day contemporary politics. And so today we're going to talk about gender and the Equal Rights Amendment. In October, on October 16th, we're going to host Professor Martha Jones from Johns Hopkins with her new book, Vanguard: How Black Women Broke Barriers, Won the Vote, and Insisted on Equality for All. And then in November, on the 13th, we're going to have a conversation with Professor Franita Tolson from USC with her forthcoming book, In Congress We Trust: Enforcing Voting Rights from the Founding to the Jim Crow Era. So it's a really great lineup, and we hope you can make time to join us for all 3 conversations. But today we're really just delighted to have for our kickoff event Julie Suk. She's the professor of sociology, political science, and liberal studies at the Graduate Center of the City University of New York, and she's also this year Florence Rogat's visiting professor of law at Yale Law School. And she has a Yale JD and a DPhil from Oxford, where she was a Marshall Scholar, and is a frequent media commentator and author. And we're going to be talking about her wonderful new book, We the Women: The Unstoppable Mothers of the Equal Rights Amendment. And joining me to talk with Julie today is Professor Katie Young from Boston College. She has an LLB from Melbourne University and an LLM and SJD from Harvard Law School, and she's the author of numerous works of scholarship on comparative constitutional law and the public law and gender, most particularly relevant for this purpose, a book by Cambridge University Press on the public law of gender with Kim Rubenstein. So thanks, Julie and Katie, for joining me today.
Thanks so much for having me. It's such a pleasure to be here in such amazing company.
And we're gonna, the way we're gonna do the format is we're gonna talk for a little bit. You're welcome to, if you have a question, to send it to us via the question and Q&A function. You can type it in, and after we've done some talking, we're gonna try and get those questions answered from the audience. We're gonna try and do a hard stop at 12:55 because we know people have 1 p.m. Things to do, but we're just so delighted that you can join us today. So Julie, maybe you can begin by just telling us what brought you to write this book, because it's a wonderful book, and you write a little bit about it. I'm going to hold the book up for everyone. We would urge everyone to buy it. We can't do what we would normally do, which is like sell them outside the function, but you can easily get this at Barnes & Noble and Amazon and your local independent bookseller. So Julie, tell us a little bit about how you came to write the book.
Great. Well, thank you so much for the question. I think I must have spent maybe 5 minutes thinking about the Equal Rights Amendment when I was in law school, and even as an early career legal scholar, focusing on equality in constitutions and anti-discrimination law. The Equal Rights Amendment was something that I knew of as kind of a failed amendment in the United States. But one thing that was very exciting in the 90s, in the late 90s and the early 2000s, which did catch my attention as an early career legal scholar and even as a law student, was development in constitutions around the world, gender equality amendments in the 90s and early 2000s. And it was fascinating to learn that these gender equality amendments were not new in the 90s and 2000s, that in fact, there had been amendments since after World War II in many constitutions around the world, many that we study as comparativists, including the German Constitution, the French Constitution, that there were these provisions, but feminists and activists were rallying around new amendments in countries around the world for gender equality to make it clear that the state had the authority, if not the obligation, to actually promote equality, real equality. And so I was studying those amendments, and then I had this kind of bingo moment, which was, well, why don't we actually think about the ERA's failure in light of this global context? And so I started writing about that, and it was still largely an abstract and scholarly comparativist project. But around the time that I started writing about it and published an article about the ERA, some states started ratifying the ERA again, and that was in 2017. So I was very interested then in writing a book that would try to think about what it means to make a constitutional amendment in the United States that is created transgenerationally, and perhaps to have something that members of the public and also legal scholars and lawyers could read, where we try to grapple with what the public meaning of the ERA is, given its long history and its transgenerational construction.
Well, it's just a wonderful book, and definitely you were perfect in hitting that tone of there's a lot in the book. It's a very meaty book. You learn a lot, but it's also very accessible to the reader. And there's some just wonderful stories, particularly about women. And so people who like that kind of book will really find a home in your book. Maybe you can take us back. I think the ERA is something that we don't know a lot about. And I know I actually hadn't known very much about the early history of the ERA. Can you, this is the year of the centennial of the 19th Amendment, and maybe you can start the story for our audience who might not even know the early history. You start with Crystal Eastman and Alice Paul, and maybe you can tell us sort of how the ERA begins in that moment in the 19th Amendment's era.
Well, the 19th Amendment was ratified in 1920, and we've been celebrating the centennial. And a lot of the suffragists, and of course, because Article 5 of the US Constitution, which requires tremendous consensus to get an amendment, you had a lot of different kinds of women with different political agendas unite around this notion that we needed a constitutional amendment to guarantee women the vote. But some of these women thought of this long struggle for the vote. It took several decades after the suffrage amendment was first introduced in Congress in the 19th century before it was actually ratified by the states. That long struggle was not actually over with the ratification of the 19th Amendment. And Crystal Eastman said, now we can begin. Finally, we can begin. And what she meant was that the vote was not just a symbol of equal citizenship. That's one way of thinking about it. It was also a weapon and an instrument to actually then address all the remaining sources of women's unequal status under the law. And so the framers of the ERA in 1923, when it gets introduced in Congress for the first time, were primarily concerned with what remained of coverture. So married women's exclusion from certain property rights in some jurisdictions, the status of mothers as legal guardians, equal legal guardians over their own children, married women's relationship to their own earnings if they worked outside the home. That is, different states had different approaches, but in some states, there were real barriers legally to women's economic independence. And the suffragists who introduced the amendment were primarily concerned with those sex distinctions in the law that perpetuated women's economic dependence.
And then you have, it sort of begins, and there's, I think particularly around the 19th Amendment, we've thought a lot about how do we tell that story in a way that is inclusive of all the voices. And one of the things I love about your book is how you make sure we have all these different voices as we go along in terms of the people who contributed to pushing the ERA forward. So we have this moment in the 20s when the ERA sort of begins, and then you have another moment in the 60s and 70s where you have Patsy Mink, Shirley Chisholm, and a lot of excitement. And I think the ERA actually passes in 71, 72, with of over 90%. So maybe you can bring our audience up to that next moment in the story.
So one of the things I try to do in the book by bringing out so many voices, including the voices of women who actually opposed the ERA in the 1920s, is to show how all of these different voices, even opposing voices, shaped the meaning of the ERA over time. And so in the 1920s, it's really women who are concerned about working women in industry. So issues of class around what equal rights can and should mean. That really arguably stall the ERA, although there are many factors, not just women who oppose it, but men who oppose it for different reasons, who stopped the ERA in the 1920s. But I think that these postponements that occur because of these different voices actually make the ERA more inclusive over time. And so then by the time you get to the early 1970s, you have 10 women in the House and 1 woman in the Senate. And you have women from different racial and ethnic backgrounds, as well as different political parties really uniting behind the ERA. And what's really interesting is that Patsy Mink and Shirley Chisholm, who are often, Patsy Mink was a real champion of working women, in not only in her work behind the ERA, but her work on other legislative agendas. And Shirley Chisholm, who's the first African-American woman to be elected to Congress, she was working on a lot of other legislative projects, including childcare legislation. Patsy Mink was working on Title IX. And so one of the things I try to show is that these different voices bring in not just a commitment to ending discrimination under the law and striking that down, but using the ERA as a political anchor for many other projects that are important to women of all different colors and classes.
And so just in terms of the sort of facts of what happens in the 70s, it gets through Congress with these incredible vote margins. I think I have here, let's see, in the House, 354 to 24, and then in the Senate, 84 to 8 in March of 72, and then out to the states, and you get 30 states to ratify, and then what happens? What stops it there in what seems to be a just splendid track record up through 72, 73?
So this also gets to why I wrote the book and what I learned in writing it, because the story that I knew and the story that's still being depicted in popular culture with the television show Mrs. America is that Phyllis Schlafly comes on the scene and kills it by saying that the ERA is bad for mothers and bad for homemakers, and rallies women who identify with those roles against the ERA. And that's only part of the story. That is, I think that one of the things that we don't really think about is the ways in which the ERA was killed by certain political structures and political dynamics, both within Congress and in state legislatures, so that the political framework actually makes it easier than it might otherwise be for a movement like Stop ERA to succeed. And what I'm talking about is the way in which, even though you get that overwhelming vote margin in the House in 1970, it actually goes to the legislative graveyard in the Senate that year, because some vocal opponents pretend that they're going to improve the ERA by tweaking the language and adding some amendments. But that's effectively a way of not having a reconciled version of the amendment that could go out to the states for ratification that year. And the deadline becomes one of the tweaks that gets discussed at that time. But of course, once the deadline is in, the clock is ticking, and some of the opponents, even though they're small in number, some of the opponents in Congress have allies in state legislatures who, again, in state legislatures, there might have been support if it made it to the floor. But in Virginia, there were powerful men in committees, small numbers of them, who were stopping it from being debated at all as the ratification clock was ticking. And then in Illinois, Phyllis Schlafly's home state, there's some controversy about it, but what actually prevails is state legislatures have total control over their rules for ratifying a federal amendment. So Illinois has a 3/5 rule. In most other states, you can ratify a constitutional amendment with a majority, like a constitutional majority, but in Illinois, it's 3/5. So even though you have majority votes in both houses of the Illinois legislature several times throughout the 70s and early 80s to ratify the amendment, it actually is not valid under Illinois, their own legislative rules. And I think when you have a 3/5 rule like that, Phyllis Schlafly's strategy becomes highly effective because her strategy is now create some confusion and doubt. And if you're working with a super majority rule, then confusion and doubt actually goes a long way in killing something.
Yeah, well, let me turn the sort of podium here over to Katie, because we are now in the modern era, like with the story. We're sort of in this period between the 70s and now when there's some actual revival around it. And I'm going to let Katie pick up with some questions from her side.
Thank you, Mary, and thank you, Julie, for this wonderful book. I think I'm hard-pressed to think of a better book to be talking about on Constitution Day this year. And there's so much about it that makes that the case. But let me single out three particular points. I think first is the incredibly comprehensible line that you draw from 1923 to today. And we've just heard of the major moments. You managed, I think, to do this without sugarcoating that history. You present the complexities behind the fact that women themselves were divided on some issues, particularly the perspective of working class women and women of color. I think secondly, the depth that you give to American feminism is just so worthy of speaking about. You really transcend a lot of, still in very important markers, such as debates around Roe v. Wade. But you move on to other battles, other stakes. These deserve their own telling, and you do it so wonderfully. And third, I think it's this gripping story, and I'm going to ask you a question about it. And this is the story you tell about the applicability of the time bar, the procedural time bar of a 7-year limit. And you tell this that, this is a very unusual time bar to place on a constitutional amendment, and it presents now a legal puzzle as to what happens. We have now Virginia ratifying earlier this year, the 38th ratification required for the 3/4 majority. And so you present a really strong case for disregarding that 7-year time limit, for actually seeing it as somehow made redundant, somehow, well, it's clearly not belonging to the Constitution itself, and therefore something that the Congress can override, or at least present a kind of need for an overt justification as to why we should pay attention to a 7-year time bar. And this comes out in the epilogue of your book, really interesting and gripping stuff, particularly gripping for a lawyer. But I think to all of our audience today, some really important stakes being raised here about what we do about these legal puzzles that many people will have different views of. And you make a very strong case, as I said, as to why we should fight for Virginia's ratification as now presenting the 3/4 required. And you make this case both, I think, for family reasons, the reasons of empowering families, reasons for empowering women. And we can see that issue redounding now with the coronavirus pandemic, revealing so many pressures that were already present, but are coming out as revealed and both exacerbated by the pandemic. So a lot of people are taking notice of pressures on women and family now. And you also make the case for observing this because of the pressures we now have on democracy. And this just redounds now as we stare into the coming election, and it's a very uncertain election, and all elections are uncertain because we don't know who's going to win. But in this case, we have an uncertainty about whether basic rule of law baselines are going to be observed. So, democracy is being put under pressure. And you make the case for also why legislatures should get to speak about women's equality rather than simply courts. I think all of these cases are really beautifully made in your epilogue. I just wonder if you could talk a little bit about some of the costs to making this case, whether we really do need to think carefully about Congress's power to override certain procedural checks, particularly because of the growing populism in our politics, the fact that there may be other substantive reasons to overlook certain other procedural requirements that had been set in times past. If you could just speak about what those downsides might be, both for women, but also for constitutional politics in general. So I'll leave that as my first question to you.
Great. Thank you so much, Katie, for that amazing synthesis and provocative set of questions. So I want to actually speak to the procedural time bar, the 7-year time limit, because there's a way in which it's both unusual and typical in American constitutional practice. So the 7-year time limit on ratification really doesn't get used at all in amendment making in the United States until the Prohibition Amendment. And when it's used in the Prohibition Amendment, after the Prohibition Amendment, all of the successful amendments to the US Constitution, aside from the 19th Amendment, the Women's Suffrage Amendment, and the 27th Amendment, which was actually adopted by Congress in the 18th century, but everything else that's done in the 20th century after Prohibition has that 7-year time limit on ratification. And the argument that I make as to why Congress has the power to override it is specific to the ERA and to the 2 amendments other than the 27th, the 25th and 26th amendments that came before the ERA. And that has to do with the placement of the deadline. That is, with the Prohibition Amendment, it was put into the text of the Prohibition Amendment itself. So it was understood that it was part of the constitutional text that was ratified by the states. Whereas Congress changed its practice with regard to the 25th and 26th amendments, actually it started to change its practice with the 23rd and 24th amendments by putting the deadline in the preamble, the resolution introducing the amendment rather than the text of the amendment itself. And the argument that I make that's specific to the 25th, 26th, and ERA is the wording of the amendment. So textually, with prohibition, the deadline was framed as this article shall be inoperative unless ratified within 7 years. The 23rd and 24th Amendment, even though the deadline was put into the preamble, it still spoke this very clear and conditional language saying it will be valid if and only if ratified within 7 years. And then by the time you get to the 25th and 26th Amendment, the language is a little bit more ambiguous. It says the amendment is valid when ratified within 7 years. So the when ratified speaks more perhaps as a prediction or aspiration, or it is at least making a deal that if it does get ratified, it's certainly part of the Constitution. But that doesn't really give you a clear answer as to what happens if it's not ratified, when the language is when ratified rather than inoperative unless or only if, right? So that different language, I suggest, is Congress's intent to leave open the possibility of revisiting the deadline. And historically, of course, Congress does revisit the deadline in 1978, when we're at 35 ratifications, time is running out. Some states like Virginia are not really debating the amendment. And it's also an initiative by the women in Congress, particularly in the House, to extend the deadline once. But the deadline extension suggests that Congress preserve that in the text, and then constitutionally, in Article 5, there's no mention of deadlines, so it's not really clear. There is litigation going on right now, actually, that's brought by the 3 states that ratified in recent years, claiming that deadlines in general are not legally valid because not mentioned or authorized by Article 5. I don't agree with that particular position. I think that it's ambiguous under Article 5, and I think that the specific textual and placement of the deadline with regard to the ERA strongly suggests that it's really up to Congress what to do about the deadline. And so then the case that I make is, I think, more of a political or moral argument than a legal one, in terms of why there are strong reasons for Congress in the case of the ERA, given its history, given the beginnings of women's disfranchisement and the difficulties of not just amendment in general. We all know that the US Constitution is extremely difficult to amend. And in fact, many people have just given up on the amendment process to fix things that a lot of people agree should be fixed in the Constitution. The Electoral College is one example. A lot of people are unhappy with it, but they would never, they're not really looking to constitutional amendment as a feasible solution because Article 5 makes the Constitution so hard to amend. I would say beyond that, that when you're talking about amendments that involve including those who are disfranchised at the founding, whether it's African Americans or women, I think there are real barriers to getting an amendment to seek your inclusion when you're not even part of, initially, the people who could possibly make up 2/3 of Congress and 3/4 of the state legislatures. And I think an ERA is kind of an extension of that fight for inclusion and inclusive constitutionalism. And I think in such cases, there's a strong moral and political case for Congress using what power it has and what power it's preserved for itself to remove the deadline to complete the ERA. I'm not sure that the argument that I'm making would apply to every possible procedural bar and every possible deadline. But that said, I think you're right. I think part of the reason also that we shy away from the amendment process is that there's a fear that opening up the amendment process will lead to the possibility of populist movements proposing and possibly even having some measure of success with regard to amendments that might actually be contrary to the values represented by the ERA. So I don't know. I mean, I do think that I think it's actually really bad that in this country we haven't had a constitutional amendment since 1992. That amendment, as I mentioned earlier, was written by James Madison. So we've really sort of lost touch with the possibility of amendment. And I think that, and I think a lot of it is driven by fear, but I think the fear leads to lack of deliberation and lack of attempt at mobilization for changes that people actually really want. And I think that fear is also part of the story of stopping the ERA. I mean, if you look back to the rule that I was mentioning earlier in Illinois, that 3/5 rule didn't come out of nowhere, and it wasn't invented to oppose the ERA. That 3/5 rule was invented during a time when there was actually a lot of amendment activity and a lot of amendment proposals in the 70s, one of which was an amendment that would have preserved the right to school prayer in public buildings. That amendment didn't succeed, but there was fear that it might. And so in Illinois, the move of trying to have a 3/5 rule for the ratification of federal amendments came out of this fear of populism. And of course, it ends up preventing the ERA as well. And that school prayer amendment, very interestingly, was actually, in addition to the 7-year deadline, they tried to actually tack on a school prayer provision onto the ERA in 1970, which was kind of a weird move. But that piece of the history kind of gets at the question that you're raising, that with every amendment that one group of people might like, there's the risk of other amendments that seem to be totally counter or speak to a different group of people. And I think that's why the founders justified such a difficult amendment rule. But I think the outcome now is that people are very out of touch with constitutional change as something they control as citizens and as we, the people.
That's such a kind of fine-grained, both lawyerly and historical analysis. So I think I'm going to take you with the next question kind of in the same place of what we do with our fears of what's coming, and turn this question more to contemporary events and also turn it outwards from America's particular experience. So you mentioned in the beginning of the webinar your deep comparativist interest and engagement, and it's been wonderful to read many of your scholarly articles about what's occurring in different places around the world around gender equality. And I, with Kim Rubenstein, have also tracked a lot of developments towards constitutional amendments, both constitutional equality, particularly in terms of male and female equality, but now gender equality. So I'm going to ask you a little bit about the trends you're now seeing comparatively. We can see that the early 2000s was a real moment, and earlier, as you mentioned, of borrowing and trading ideas and assisting local feminists with ideas and lessons of equality amendments, and a real time of optimism for different versions of feminism, but taking place in different parts of the world. We might say that that moment has reached its high point and has been eroding or backsliding in years since, particularly in the last decade. We've seen the rise of so-called anti-gender ideology or anti-gender groups, both powerfully state-sponsored groups and campaigns, and also social movements that come out opposing what they see as a feminist agenda or a gender agenda, and they label this on many fronts. And this isn't a monolithic group of activists, but oftentimes there's real strains of anti-LGBTQI expression, also expressions against simple women's equality and assistance of women in various workplaces or in the home. And this has come out across Europe, and we see these movements in France and Germany and Italy and Hungary and Poland. It's also occurring in Latin America, and we can really see some notable examples in Colombia and Brazil. And not always is this engaged by the state, but oftentimes it is as a platform, a political platform. And so I wonder, given these trends, these contemporary trends we're seeing, and the kind of scapegoating as feminism, as gender equality as one of the problems that can be associated with grievances that need expression. Given these trends, do you see the comparative outlook as a hopeful outlook, as it was in the 2000s for feminist equality movements, or more as a cautionary outlook, a kind of cautionary tale of backlash against these kinds of amendments?
So it's a really tough question, and it's so hard to predict, because certainly when I started this project and when I was writing about the ERA and comparative perspective, one of the models that I was looking at, of course, was the German Constitution, because they had an amendment in 1994. They had an amendment that added on the post-World War II Constitution. The post-World War II Constitution just guaranteed equal rights between women and men. And in 1994, a sentence was added to that paragraph saying that the law shall promote the actual implementation of equal rights between women and men and eradicate disadvantages that now exist. And it was widely understood by many jurists and by the Federal Constitutional Court and the regional courts that provision meant that if the legislature passed statutes requiring, for example, quotas to increase gender parity or the representation of underrepresented sexes, like namely women, that would be permitted. And it's just recently this year, though, that you've seen a regional constitutional court in Germany strike down a gender parity rule applying to a political party, despite the fact that that provision was there, and everyone for a long time widely understood that provision as authorizing gender parity legislation. They've struck it down, invoking the right to vote, actually. They're saying that it violates both political party freedom and the right to vote if a political party is required to pick an equal number of female candidates as male candidates. And so that goes to show that also things that you thought were very clear as a legal matter, when you have backlash, get reinterpreted and can be given new meanings, although the fight is not finished. There are other regional courts that are taking decisions on similar measures, legislative measures undertaken by their localities, and eventually reach the German Constitutional Court, the Federal Constitutional Court. And I think you get a mix of different developments. You get backlash on the one hand. On the other hand, there are these interesting things that have happened. So in Chile, there's going to be a plebiscite in October. It was supposed to be earlier, but it got postponed because of the coronavirus, in which they're proposing to write a new constitution with a constituent assembly, possibly elected under conditions of gender parity. And so it's hard. I'm hopeful that the plebiscite will veer in the direction of having the gender parity constituent assembly, but it's not by no means clear whether that's what will be produced by the plebiscite. And then in countries like Ireland in 2018, you saw a constitutional movement led by women that repealed the prior amendment from the 80s that banned abortion essentially as a constitutional matter. So I think you see a mix of developments, and I think all of them are contingent and are up to women and feminists and their allies. And I think it's all in the process of being made. And I think that's the thing that we don't quite understand. I often get asked, will the ERA necessarily do X, Y, and Z? And often my answer is the ERA has these words that can mean a lot of things. So it actually depends on what we say now in legislative history we want the ERA to do. And it depends now on who we elect to pick judges and how they then interpret. And so it's all being made, right? That in some ways people can control what happens by whether or not they pick legislators who are going to remove the deadline, and more importantly, hold hearings while they remove the deadline so that we can actually say what we think these very abstract words in the Constitution should actually do or mean. And I think this sense of agency is important. I think you're right that there are obviously a lot of forces that are being unleashed, but I think it's just going to be a struggle to see who has the political will to persist to advance their ideals.
Julie, one of the questions, some of the questions we have from the audience involve really this last point that you've talked about, which is sort of what would the ERA do today? And so maybe you can help us think about that. One of the figures who looms really large in your account is Justice Ginsburg, both particularly in her work as a lawyer in the 70s, and then again as a justice. And maybe you can talk about, she was the author of a lot of the 14th Amendment interpretations around equal protection that might suggest to some people, well, we don't really need the ERA. So maybe you can talk a little bit about that. And then are there any downsides to passing the ERA, sort of like what would it be? So maybe sort of like, why do we need it despite a lot of 14th Amendment equal protection around gender? And then what are the possible downsides?
Great. So I think that the ERA, when it was adopted in 1972, and actually when it was, when it really got off the ground, the version that we have now in 1970, the Supreme Court had not actually ever struck anything down based on equal protection for being sex discriminatory. So you get Reed versus Reed, and Ginsburg's brief in Reed versus Reed is a tour de force, and really you see it shaping the equal protection law around sex discrimination from 1971 and throughout the 1970s. And so that was so what they wanted with the ERA was actually achieved through litigation and through reinterpretation of the 14th Amendment. And there's actually a judicial awareness of the importance of the movement for the ERA in producing this evolution. So in Frontiero versus Richardson, the justices on different sides, they can't really agree on what the standard should be on how to scrutinize sex distinctions, but the justices do actually explicitly mention the ERA as something that is driving a change with regard to how they're interpreting the 14th Amendment as it relates to sex equality. So I would say that, and this is one thing that I think is important, I think the ERA has actually changed the law, and women have actually changed the law even without the ERA being fully legitimized as a formal constitutional amendment. And I think this is one of the strongest arguments in my view as to why we should complete the process, because women have invisibly changed the Constitution, but their contributions have not been legitimized. And I think that's what I've just said is also a way you could describe the sources of gender inequality in society, that women perform all kinds of invisible work, both care work and underpaid work in the economy that is undercompensated and underrecognized. So I think that's the main reason why it's important. But I think to the extent that we expect the ERA to do something doctrinally that the Equal Protection Clause doesn't do, Ruth Bader Ginsburg, shortly after United States versus Virginia was decided, said, we achieved everything through interpretation of the 14th Amendment. And I think, and so we have this de facto ERA on the one hand, but I don't think it's fully true, because one thing that you see very strongly in the 70s discourse around the ERA is, and it dates back to the 20s, there's this real question, if you have something that's actually a special protection for women, is the way to equality to level down by getting rid of it, or level up by expanding, say, a labor protection or an exemption from compulsory military service? You can level up and say, you know what, now everyone's going to be free from compulsory military service and we're going to have a volunteer army, right? That's one way of doing equality. Another way of doing equality is to just get rid of anything that's special for any and anything that might be a privilege for one gender. And I think there is a strong discourse created in the 70s legislative history that the ERA, anything that's actually helpful to women, you won't get rid of. You'll probably try to expand it to include men and all genders as well. And I think that's something that actually has not been part of equal protection sex discrimination law. So the Supreme Court decides Morales-Centeno just a few years ago, and the court explicitly says the Constitution doesn't tell us how to get to equality. And I think there's a strong argument in the 70s legislative history that there's more of a direction towards leveling up with the ERA than you have with the 14th Amendment. And also, there's also with the ERA a more legislative understanding of constitutionalism, not judicially focused, because women like Patsy Mink and Martha Griffiths, they didn't really put a lot of faith in the Supreme Court's ability to deliver gender equality. They said, we want the ERA so that the courts start striking down sex discrimination. But really the meat of the ERA was giving a nudge to legislators, both at the state and federal levels, to do the heavy lifting. So the Title IX, the child care legislation. And so it was to give political legitimacy to that by way of congressional authority in Section 2 of the ERA to enforce the ERA, and even by way of something that looks, that is not apparent when you look at it, the 2-year delay on the effective date of the ERA. The 2-year delay, Martha Griffiths said in all her testimonies, was designed so that Congress and state legislatures could actually take a stab at making their laws equal. And that meant repealing, but not just repealing anything that made sex distinctions, rewriting so that it would be compatible with a robust vision of equal rights. And that's something that actually carries over when Nevada ratifies in 2017. Pat Spearman, an African-American woman who leads the effort in Nevada, she quotes Justice Ginsburg, not just a Ginsburg article from the 70s, saying the ERA is about legislatures going through a thorough effort of legislative revision in the 2 years before effective date, and only failing legislative action, judges step in, right? And I think that's actually a very different understanding of what an amendment that guarantees rights does. And you might say that the way that the ERA might actually work in practice is more 20th century, perhaps more attuned to the way that constitutional courts around the world do an analysis known as proportionality, rather than regarding the right as just a trump to strike down any kind of sex distinction that exists. So I think it provides all these resources, but as I said earlier, it is something, the words don't really get us there by itself. I think it's the legislative history and legislative history that continues to be made, not only with the 3 states that continue to ratify. There are states that are still continuing to ratify, which I think it's still important for additional states that have movements to continue to ratify, in light of the fact that we haven't talked about this, but there are some states that rescinded, and there are interesting questions raised by the status of those rescissions. But I think some of those doubts about rescission will go away if more states actually ratify. the ERA. And I think there's opportunities to create legislative history with those additional ratifications. And there's opportunities to create legislative history with forthcoming, well, I hope forthcoming congressional action, in addition to the House's vote this year. If it has to go back to the next legislative session for the House and the Senate to consider the deadline removal, I think that's an opportunity to create meaning and to solidify a 21st century understanding of rights.
Katie, you want to pipe in with
Yeah,
another
I might
question?
just pick up on that last thing about, so much that's changing in the 21st century about rights. And I want to ask you a little bit about what we've seen here as described as fourth wave feminism. And this is feminism associated very much with the Me Too movement. Now feminism very much informed by the intersectionality problem, the problem that non-discrimination of race and racial discrimination protections can sometimes ignore gender and vice versa. And the feminism we have today is very much aware of that problem. It's aware of health and reproductive rights, transgender rights and other issues. And I just wondered if you could explicitly say how much this fourth wave feminism, if I can call it that, has changed the pros and cons of passage of the ERA. What does it bring? What does it change about what the ERA will do, or the risks involved in entrenching an ERA now?
So I think that in the 70s, for sure, there was not much thought given to the meaning of on account of sex as including discrimination on the basis of sexual orientation and gender identity. There was a little bit of thought given to that, and even the ERA's most vocal proponent, Martha Griffiths, sort of brushed it off. I think somebody said, "Isn't this going to lead to same-sex marriage?" And she said something like, "Why would it lead to something so silly?" The legislative history created in the 70s suggests they were primarily concerned with inequalities that women faced under the law and in society. But fast forward to now, it's actually been a very important part of the ERA's legislative history and the ratifications in Nevada and Virginia for sure, and arguably also in Illinois. But in Nevada, the primary sponsor is Pat Spearman, who is a member of the LGBT community, African American, served in the military for decades, fought Don't Ask, Don't Tell, has been very vocal about her role in fighting Don't Ask, Don't Tell as a member of the LGBT community, and very vocal in her understanding that ratification of the ERA now includes equality for everyone, including people who might be discriminated against because of sexual orientation and gender identity. In Virginia, very important speech given on the ratification floor by Danica Rome, who is the first transgender delegate to be elected in Virginia. And she talks about the importance of the meaning of on account of sex today in the 21st century as including protections against discrimination for people of all genders and gender nonconforming people. And I think that's also one of the beauties of a transgenerationally made amendment, that the word sex actually has evolved in the 70s. And so it actually means something different now. And the legislative history is kind of affirming and solidifying this different meaning. But I think that said, I think there are some dangers and downsides if we're not really thoughtful about it. In that, I mean, if you think about the Supreme Court's recent decision in the Title VII case in Bostock versus Clayton County, the Supreme Court takes an approach where the inclusion of sexual orientation and gender identity is really based, I think, in too formalist an understanding of what it means to discriminate. That is, it's the very act of taking sex into account. And Justice Gorsuch argues that if you make a decision based on sexual orientation or gender identity, you're taking sex into account, and that's what's problematic. And I've been troubled by the way that that case has been relied upon now in some, at least in some amicus briefs, in litigation challenging California. California passed a corporate board law a couple of years ago, requiring that at least one member of every corporate board in California be a woman. And that has immediately invited litigation under the 14th Amendment. And part of what I've been saying all along in this conversation is that I'm hopeful that the ERA, like some of the more recent amendments in the European context, could clarify that sex distinctions that are made to actually overcome disadvantage based on gender and disadvantage or underrepresentation of women, that those things would be permitted, if not encouraged or obligated by the ERA. So I think the ERA can clarify that. But if our way to transgender rights involves total formalism and a total skepticism of any form of sex distinction, if that's how we get there, then you are going to see a clash between that vision of the ERA and a vision that is substantive equality based and permits and encourages gender distinctions in situations where you want to overcome power imbalances and underrepresentation. So I do think that we have to be careful about it. And one of the downsides of having an ERA is that sometimes there's a lot of conflict about meaning. And so even though our aspiration might be to include everyone and to allow for all these things that we identify with progressive causes, that might, the reality on the ground in terms of judicial enforcement and the multiple actors who claim the ERA's protections, it might not necessarily shake out in precisely the way that the proponents want.
I mean, Julie, one of the things that I really think your book does so well is this point that you're talking about, how there were so many voices and their beliefs in what the ERA could do in particularly trying to improve actual people's lives, give meaning to the text, that rather than the text sort of very narrowly describing by a dominantly white male judiciary what rights are, that people can come to understand their rights by sort of advocating. And I'll just show, there's just all these wonderful color pictures in the book. I can't imagine a book about constitutionalism and constitutional authorship that so powerfully communicates the number of women and the diverse people who basically are trying to author the Constitution, even though we don't tend to think about it that way. And for me, that really was one of the really reaffirming aspects of this book. Well, we've come to the end of our time with Julie. The time flew so fast. I know Katie and I could sit here for hours talking. We're so happy that you were able to join us today. We hope that you'll be able to go and buy Julie's book. It's a really thoughtful book. You learn a lot. You learn all sorts of things that I didn't know. My book is filled with little pencil marks, exclamation points for information that I learned along the way. Lots of good tidbits, wonderful pictures. I found it certainly very inspiring. Katie, you want to have 1 second and then I'll just close formally?
Equally, I just enjoyed the read so much, and I think we've talked a lot about many of the things you bring to the table. We could have talked so much more about the double entendre of the title, and there's so much that I know Mary and I want to continue, but I want to really thank both of you for being part of this. This has been really, really fantastic.
Julie, thanks. Thank you so much. We're just really delighted that you were our guest. Thank you.
Thank you. It's been a great conversation, and I really hope it's not the last between the three of us and many more about these issues.
Yeah, no, I sort of feel like we could have a regular Friday lunch talk. Well, we want to thank everyone who ate their lunch and listened to us at the noon hour on Friday. We hope you'll come back in October when Martha Jones will be our guest, talking about her wonderful new book also on the 19th Amendment. And then in November when Franita Tolson will be our guest, talking about, in the post-election moment, her book on Jim Crow laws and 19th century elections. So we really look forward to seeing you then. Thanks for joining us, and have a nice Friday.